What if I told you the United States Constitution never actually says the Supreme Court can strike down laws, and yet, that is exactly what the court does. Today we're going back to the year 1803, the case Marbury versus Madison, the decision that gave the courts their superpower, judicial review. And we'll end with how this 200-year-old case is shaping battles at the Supreme Court right now. The year is 1800. President John Adams loses the election to Thomas Jefferson. Before leaving office, Adams scrambles to fill last-minute judgeships. They're called the midnight appointments. One of those appointees is William Marbury. But his paperwork, his commission, never gets delivered in time. When Jefferson takes office, his new Secretary of State, James Madison, refuses to hand it over. So Marbury goes straight to the Supreme Court. He asks for a writ of mandamus. That's a court order forcing Madison to deliver the commission. Here's the twist. Marbury relied on Section 13 of the Judiciary Act of 1789. That section said the Supreme Court could issue the writ directly. But the Constitution's Article 3 didn't clearly allow that. This set up a head-on collision, Congress versus the Constitution. Enter Chief Justice John Marshall. He pulls off one of the cleverest power moves in legal history. First, Marshall says Marbury had a right to his commission. Second, there should be a legal remedy when a right is violated. Third, but this Supreme Court could not grant it. Why? Because the section of the Judiciary Act that gave the court this power went beyond what the Constitution allowed. Therefore, that law was unconstitutional. And then Marshall drops the famous line. It is emphatically the duty of the Judicial Department to say what the law is. In one stroke, the court refused to give Marbury his job, and at the same time claimed the power of judicial review. That decision came on February 24, 1803. From that moment forward, federal courts had the power to strike down laws that violate the Constitution. It became the backbone of huge cases, Brown versus Board of Education, United States versus Nixon, and many more. Whether it's civil rights, presidential power, or separation of powers, Marbury set the rule. The Constitution is supreme, and courts enforce it. You might think Marbury is just dusty history. Not even close. The Supreme Court still leans on it in today's biggest fights. Example 1. Loper Bright versus Raimondo, in 2024. This case ended Chevron deference, the old rule that said courts should defer to federal agencies when laws were unclear. The court quoted Marbury directly, saying it is judges, not agencies, who must say what the law is. This was huge. It shifted power away from agencies and back to the courts. Example 2. Presidential power. In 2024, the court heard Trump versus United States. The question was, does a president have criminal immunity for official acts? Both sides invoked Marbury. The majority opinion recognized significant immunity for official acts. Once again, Marbury framed the fight about what role the courts play when executive power is on the line. Bottom line, whether it's agencies or presidents, the fight always comes back to Marbury's central idea. Courts say what the law is, even if that means checking the other branches of government. Marbury versus Madison wasn't really about one man's job. It was about whether the Constitution had teeth. By striking down part of one statute, the court gave itself a duty and a limit. To say what the law is, not what it should be. Love it or hate it, that principle is the engine of American constitutional law. And it still drives the biggest Supreme Court cases today. If you learned something, hit like, drop a comment with the next Supreme Court case you want me to cover, and subscribe for more sharp, simple breakdowns of the law that shapes your life.